Hello, everybody. I'm going to be going over the competency to plead guilty. My name is Vanessa Hernandez. So let's get right into it. Just a quick introduction. 90% of all criminal cases are resolved by guilty pleas. So usually criminal cases are resolved by guilty pleas because of plea bargains in order to reduce sentences. So guilty pleas must be knowing, intelligent, and voluntary, much like a confession. So what does knowing consist of? Knowing pleas must display comprehension of the nature of the charge pled to, the penalties associated with the charge, the rights waived by the plea. So the constitutional rights that are waived by a guilty plea are the right to remain silent, the right to confront one's accusers, the right to a jury trial, and the right to trial counsel. The determination of whether a person or a defendant is competent to plead guilty is made by a judge at the arraignment, where the assumption would be that the lawyer believes that this is the best course of action and has already spoken to the client about the ramifications of a guilty plea. So one of the first cases where competency to plead guilty is first brought up is Sealing versus Iman. In 1973, Gilbert Sealing was accused of multiple counts of assault, as well as assault with a deadly weapon and intent to commit murder. Two of three psychiatrists assessed that Sealing was competent to stand trial. Before the trial date, Sealing withdrew his plea and decided to plead guilty. After he was sentenced to 16 years in prison, Sealing petitioned for a writ of habeas corpus, arguing that he had not been competent to plead guilty. The Supreme Court did take this case, and one of the things that they determined was that a defendant is not competent to plead guilty if a mental illness has substantially impaired his ability to make a reasoned choice among the alternatives presented to him and to understand the nature of the consequences of his plea. They also said that the degree of competency required to waive a constitutional right is that degree which enables him to make decisions of very serious importance. So, what they were basically saying is that the competency to plead guilty should be higher than the competency to stand trial because of the fact that a defendant would be waiving constitutional rights in order to put in a guilty plea. But we do go into the 90s, and the question is raised again in Godinez versus Moran. So some facts of the case are that Richard Allen Moran shot three people and himself. Initially, he did confess to police officers that he shot three people. This was after he was given his Miranda warning, but it was before he received counsel. So there was some question about whether the confession was admissible, whether it was not admissible. But Moran had initially pled not guilty to three counts of first-degree murder. He was found competent to stand trial, but 2 months later, he dismissed his counsel and withdrew his plea, giving a guilty plea instead. And his reason for this was that he did not want any mitigating evidence on his behalf during the trial. During this period, Moran was on 4 different types of psychiatric medication. This is important to note because the trial judge did ask him if he was on any type of drugs or medication that could have altered his thinking or his perception. And he did answer by saying, whatever it is that I'm getting at the hospital is what I'm taking. And it did turn out that it was 4 different types of psychiatric medication that could have altered his thinking. The trial judge asked if he understood the rights he was waiving, and Moran replied in the affirmative, so he agreed that he understood. Once he was found guilty and sentenced, Moran then petitioned for a writ of habeas corpus due to his mental incompetence to plead guilty. But in this case, the Supreme Court came to the conclusion of the opposite, that the competency to plead guilty is not higher than the competence to stand trial. So if you're competent to stand trial, you're competent to plead guilty. So what do you think? Do you think that we should hold ourselves to the Moran standard, or should we hold ourselves to the ceiling standard? Um, just a couple of things to note. Federal courts in most states use the Moran standard. Um, One thing sort of against the Moran standard is that most defendants do not have to consider waiving their constitutional rights. So even if they're competent to stand trial, it doesn't necessarily mean that a defendant would understand that they're waiving constitutional rights in order to plead guilty. So that would be kind of something more towards the ceiling standard. But on the other hand, if we were to follow ceiling, it could result in less defendants capable of utilizing plea bargains. So if they're found competent to stand trial but not competent to plead guilty, they would not be able to come into a plea bargain agreement. And that might be better for most defendants to be able to go into a plea bargain. So one of the assessment tools that are used um, to gauge whether someone is competent to stand trial or competent to plead guilty is the MacArthur Competence Assessment Tool for criminal adjudication. This is the standard evaluation of a defendant's competence to proceed. It does have an assessment of their understanding of the charges and the consequences, and it does assess their familiarity with the nature of the process, which includes the trial rights way through a plea. Sorry. Um, as an evaluator, you would want to assess their reasons for entering a guilty plea. So you'd want to differentiate between rational and irrational reasonings behind the guilty plea. So if somebody wanted to enter a guilty plea because, you know, they're from planet Mars and the government told them to, that's obviously an irrational plea, an irrational reasoning. And if it was, oh, I feel guilty and I feel like I should face the consequences for what I've done, obviously that would be irrational reasoning. You'd want to make sure that they were knowing so that they understood um, the significance and the consequences of the particular decision that they're taking. And is this voluntary? Was this decision coerced by, law enforcement, family members, defense attorneys, anybody else besides the defendant? But ultimately, it is the judge's determination on whether or not a person is competent to plead guilty. So again, it's going to be up to the judge whether the defendant's plea meets the requirement. If the defense attorney agrees with the defendant's plea, the plea should be accepted. But when the judge and the defense attorney do not agree, the court should assess the defendant's reasoning for the guilty plea. If it is a well-reasoned choice, it may be accepted. These are some of my references that I used in order to make this presentation. So I hope that you enjoyed. I hope that you were able to understand the standards that are being utilized today for competency to plead guilty. If you have any questions, please reply to this lecture and let me know, and I will do my best to assist you. Thank you so much. Have a great day, guys.